I'm delighted to introduce you today to today's speakers, Barbara Juvan Clark and Danielle Groupchang. Barbara Juvan Clark is a senior trial attorney and team lead at Blackstone Law, where she champions the rights of California employees in individual, class, and PAGA actions. She is a passionate advocate for women facing workplace discrimination and harassment. Notably, she served as co-counsel in the Young versus Department of Public Social Services, helping secure the 7th highest employment law verdict in California in 2022, and continues to lead impactful litigation on behalf of thousands of workers. Danielle Groupchang is a senior associate attorney at Blackstone Law, where she specializes in wage and hour class actions and is a dedicated advocate for workers' rights. Coming from a family rooted in the restaurant industry, Ms. Groupchang brings a personal understanding of the challenges faced by the working class Californians. Her lived experiences fuel her commitment to ensuring employees are treated fairly and compensated lawfully under the law. We're so happy to have you both. Now let's get started.
Thank you so much, Andy, for that wonderful introduction. Okay, so we are going to be bringing you our presentation. It is bringing the pieces together, pre-mediation steps for better outcomes. It is going to be a chronological step-by-step of the kind of tips and tricks that we like to utilize to really make the most out of our mediations and to ensure that, we can meaningfully use the time that we have with the mediator that we've, at that point, probably waited 6 to 9 months to be in front of. Rin, if we could have the next slide, please. Thank you. So first, mediation checklist. We have provided you with a mediation letter as well as with a timeline, and together those two things can serve as a checklist to get yourself prepared for mediation. It contains general questions and specific questions, and while, on the onset of your case, you don't necessarily need to know that information immediately. You do need to have that information handy prior to mediation. And so attorneys should plan to know the answers to all of those questions, even if the answer to that question is no, there are no CBAs, or no, there is no alternative workweek schedule. But you should make a plan to confirm that information, and whether that's utilizing some of the other resources that you might have or asking defendant directly, it's important information for you to have. Next slide, please, Rin.
All right, so the first steps with regard to preparing for mediation and making sure that you have the best outcome possible starts months and months and months prior to your actual mediation. So you should, for both sides, both plaintiff side and defense, make sure that you are talking to your client and gathering all of the documents that you can possibly get that relate to the claims and defenses at issue. And having conversations with your clients as opposed to just sending emails or memos or things like that are very, very important. I think that one of the overarching themes for today really is establishing valid and open and frequent communication, not just with your own client, but also with the other side, because the more conversations that we have, as opposed to emails that get exchanged, the better the outcome, the better the information. And sometimes talking through some of these issues is the best way to actually prepare. So with regard to the defense, make sure that you are having this conversation with your client, particularly if they are unsophisticated or if they've never been involved in litigation before, so that you can set their expectations regarding what settlement value range could look like, what exposure is, whether there's EPLI, the timelines of things that you will need to receive from them. And on the plaintiff side, making sure that you are communicating with your client regarding their expectations as well, because obviously class and PAGA recovery is very different than an individual case. Sometimes there are individual claims that are also going to be mediated alongside of a class and PAGA, but we're not really delving into that today. But it is always very important to make sure that your client is on the same page in terms of expectations, timelines, and communication. So that also involves making sure that you are using language that's appropriate for your client and making sure that you're making a connection with them. So that also involves frequent check-ins, and making sure that your client is updated on a regular basis. If you are a firm that has support staff, and I know that there are solos and small firms that don't have as much support staff as larger firms. But if you are fortunate enough to have talented support staff, have them set a schedule and make sure that your client is receiving regular check-ins and that they are following up for information or answering questions and things like that. Also, with regard to the expectations, discuss early mediation with your clients. So I know that that is oftentimes looking toward the end of a case, but I think that the best way to approach any case is to look at the end from the very beginning. Okay, and the next slide, please.
So this slide is with regards to client management. Client management is certainly one of the many things that could derail a mediation if you haven't been working on that from the outset of your case. On the plaintiff side, like Barbara's mentioned, one of the most important things is to set expectations regarding compensation. Nothing worse than mediating a whole day and then you come back to your clients, you're kind of getting ready to discuss some, tighter numbers and they are blown away. They have, they're so upset. They haven't expected that that's what the numbers were going to come down to. And if you had worked on that client management aspect, if you had worked on kind of communicating to them as the case was going on, different reasons why your expectations for how the case might settle, where it might settle, then you've missed an opportunity to kind of nip that in the bud. And so another thing that's going to help you with that is establish trust with your client, making sure that you have the settlement authority, making sure that they respect your opinion. And I think that one of the best ways to establish that is for them to feel like you respect them in turn. Another thing that we like to do is from the outset, we ask our plaintiffs to start gathering contact information for possible declarants. This gives you contact information as you're ramping up your case, as you're getting ready for mediation, for you to call those people, ask them what their experiences were. You can get declarations for mediation. You can have more than just, according to my plaintiff, they worked during their rest breaks. If you're able to back that up with declarations from third-party witnesses, from other putative class members or grieved employees, that'll have a lot more weight when you get to mediation. It'll show the mediator, not only have you done your homework, but that, perhaps many of the violations that don't show on the records, that they will have more weight and more merit because you have the declarations to back them up. Another thing with plaintiffs is you want to discuss their timelines. You want to make sure that they know this is certainly a marathon, not a sprint, that this is something that's going to take a little bit of time. And, I like to tell my plaintiffs, this is not something that you need to have at the forefront of your brain. You don't need to worry about this every day or, think that something new is going to happen every day. This is something where we can connect once or twice a month. And like Barbara said, we can make sure that we have these regularly scheduled check-ins, and we love to utilize our support staff or some of our junior attorneys. It gives them great experience to start working on their skills to build those relationships. On the defense side, I think it's so important for attorneys to really determine who has that firsthand knowledge of an employee's day-to-day, who is able to answer questions for you like, where do they take their rests? Where do they take their lunches? Where do they clock in? Where are their lockers? People who are really, truly going to understand what the day-to-day work and what the experiences of employees are so that you can better advocate for your client. Another thing that you're going to want to do is identify who the decision makers are, and figure out what their natural inclinations are towards risk. If they are more risk adverse, if they're willing to take risks, perhaps they want to see a little bit of litigation before they feel that they're ready to go to mediation. It's important for you to know those things. And kind of finally, on the defense side, I would urge you to kind of make sure that everyone, these decision makers, the people who are going to be present at mediation, your point of contact, that they understand a lot of these key processes about, approvals of a class or PAGA settlement, work week and pay period values, and why it's important for them to get those data points accurately, and escalator clauses. I think once you have those kind of concepts explained to your client, then that gives them a little bit more buy-in and understanding as to why those data points are so crucial to you and why it's important for them to get them right. The next slide, please, Rin.
Nope, that's fine. And so with regard to client management from both sides, the key theme, again, for both sides is really communication and having those conversations with your client and with declarants and going to the site potentially as a defense lawyer and speaking with those key individuals that will facilitate you having a better and more informed conversation with your opposing counsel as well as with your mediator later on. So I think that it's not merely client management, it is also facilitating the road ahead. So with regard to this slide, so engaging the right team. So with regard to your data and your documents, so I think that the proper thing to do is to engage a data analyst. And I think that there are firms that don't do that. They do the data analysis and document analysis in-house, and the difficulty on that from a plaintiff's perspective is that is attorney time that is taken up, and it is time that is not necessarily separately compensable because the fees that are approved later on are on a percentage basis as opposed to on an hourly basis. And those countless hours of doing the math would be counted in that percentage. Whereas if you send your data and documents to an analyst, someone who is qualified and trained to do this and does nothing but this, that is a recoverable case cost later on. So as a plaintiff's lawyer, I think that the proper thing to do is to send that out for analysis. And that will save you both on time. And, if we were good at math, we wouldn't have gone to law school, right? We would have done med school or engineering or something else. So certainly there are those of us who are good at it, but send it to those who do this all day, every day. Also, when you file your complaint, I recommend sending your complaint to your data analyst, or on the defense side, as soon as you get that complaint, send it to your data analyst as well. That secures your preferred data analyst for later on. And the great thing about that, you never need to tell a soul that they have already been retained, right? And so you're not tipping your hand, you're not doing any of those kinds of things, but you are retaining the right team, the people that you are familiar with, that you like working with, that you know you can count on to do your analysis the correct way. Second to that is something that you should be doing on the regular, both again on the plaintiff side and on the defense side. So building relationships and investing time and effort with the mediators and with their case managers. So the case managers are often unsung or forgotten heroes in our mediation story. And they are the ones that can tell you, oh, this person has a cancellation 3 months from now, instead of their availability being in April or May of the following year. And they are the ones that can help facilitate getting you in with the mediator of your choice. So I definitely think that it's worth investing in time with the support team for the mediators and the case managers over there. And building relationships with the mediators. So I firmly encourage that you attend things like the judicial events that the Beverly Hills Bar Association held earlier this year, where you can actually speak with a lot of these mediators and a lot of these very recently retired judges who are going into the mediation and arbitration practice. You want to find out about them, find out what they like, find out what they don't like, how they approach mediation, because there are mediators who have different approaches, right? Some of them nowadays are doing this kind of mediator's proposed bracket to narrow the field and hopefully get to numbers quicker in the day. Some of them are old school and they like to have this back and forth on a factual analysis, and they don't even get to numbers until after lunch. It really, you have to know what your mediator's approach is. Some mediators still do an open session to start the day. So you have to be aware of what their preference is, how you are going to discuss the facts with them, and making sure that you're investing in those relationships as well. Again, also a common theme throughout today is utilizing your support staff throughout the process. And it could be as simple as having them contact the mediators for availability, for making sure that they are scheduling these connections, or as we have on the timeline, making sure that those dates and deadlines are scheduled so that you can have these check-ins with your clients, with the other side, with your mediator, those kinds of things. And we can go to the next slide, please.
So in terms of the timeline of where we are in our case is still recently filed. And so this first step is kind of figuring out whether or not it's appropriate to set a mediation. And I think the first step to that, and it's kind of underutilized and it seems so obvious, is to just have the conversation. You're truly not putting yourself at a disadvantage by just opening up this channel of communication, having a conversation about it. And I would really encourage you, particularly if your case is a class action, it's likely in a complex court. There's probably a CMO. You're probably required to do a joint ISC statement. And many judges, many of CMOs require you to state whether or not you have considered early mediation or whether or not you're open to ADR. Make that more than just a throwaway sentence in a joint statement. If you see that the defense or that the plaintiff side, the opposing counsel, has put that they're open to ADR, talk to them about it. Why not ask? I noticed that you put that you're open to ADR. What do you think about that? Do we want to see if we want to see what kind of availability there is for a mediator? You're likely not going to see a mediator for 6 to 9 months anyways. And in that time, you can still continue to build up your case. But I would encourage you to ask, because you'll never get what you don't ask for. And what you're looking for here is not necessarily the mediation, but the information. You want to know if mediation isn't appropriate now, why? When will it be appropriate? That way you can adequately throw your resources into something that's going to meaningfully move your case forward, as opposed to just litigating smaller issues just for the sake of litigating them. And I think, if opposing counsel isn't understanding, why you're asking about early mediation, don't shy away from explaining it to them. It saves all of the parties time. It saves everyone resources. In particular, for a defense counsel, it would save your clients work week accrual. The earlier you get into mediation, the smaller that work week or pay period number is going to be. And on the plaintiff side, if the defendant is all of a sudden changing their policies in response to your lawsuit, then you're also going to save dilution. You're not going to have all of these work weeks and pay periods that are associated with new, better, stronger policies. When you get to mediation, it's not going to dilute the violation rates. And I would also finally encourage you to have explicit conversations about the scope. In today's day and age, when we practice class actions in PAGA, we obviously are seeing a lot of arbitration agreements. Barbara's already mentioned that our clients may have individual claims. Why not be explicit about the possibilities of the scope of mediation so that you have put that information out there, so that you can say what you think the appropriate scope is, and you can have an appropriate conversation about why or why not what you've proposed is the appropriate scope. But I think if you're not willing to have that conversation, it is certainly one of the other things that could just blow up your mediation and have wasted all of the parties' time because you were unwilling or maybe even apprehensive to have that discussion and to bring up some of these topics.
And with regard to the scope specifically, if there are individual claims, like if your individual plaintiff has a FEHA or an 11025 or any other individualized claims that are not part of your class or PAGA case, the scope absolutely needs to be very clearly communicated to the other side, because as a defense counsel, you want to know from your client, is there EPLI? Is there separate coverage? Is there separate counsel for these individual claims? And so you have to be able to adequately prepare for mediation. So one of the things that Danielle and I believe is a best practice is when you are booking that mediation, you put it in that email and say explicitly, this mediation will be class, PAGA, and individual, or if there has already been motion practice on an arbitration and that was successful, then it's PAGA and individual wage and hour claims. Whatever it is, be explicit and be on the same page. And it's all about, again, communication. So if we could do the next slide, please. Selecting a mediator. Again, this is where having all of these networking events and meeting these mediators and judges who are going to be retiring and who are going to be engaging in mediation and arbitration, this is where this is very crucial. You need to develop these relationships so that you have an understanding of their approach to mediation, their valuation of cases. I had a mediator one time tell me that his favorite kind of cases were class actions because all he needed to do was get out his calculator. So that was quite interesting. That was a piece of information that I didn't have before. So you want to make sure that you are having a mediator who is the right fit for you and for your case. So there are mediators who are very aggressive, and that is how they practice. If that is not your style, if you have a client who's very sensitive or emotional, or if your defense client is not sophisticated and has not been through this process before, that might not be the right fit for you or for this case. So you might want someone who has a little bit of a softer touch, whatever that is. So you also want to make sure that they are going to have availability. Most of the great mediators, again, they're currently booking somewhere between 9 and 10 months out, and that's not always a negative. Certainly work weeks and pay periods and things like that continue to accrue. However, you should never waste that time. You should always be making sure that you are making strides towards learning more information, having these regular check-ins, all of that kind of stuff. So even though availability is going to be an issue with the vast majority of quality mediators, it doesn't have to be. And again, make sure that you are in with those case managers and that you're having these great check-ins with them, because they will let you know if there are cancellations. Cost is also another consideration. And some mediators now are $30,000 a day. Some of them are $10,000 a day. What is your budget for this case and what is appropriate for this case? So there are certainly mediators who have better availability, who are less expensive. There are other mediators who are far more skilled, particularly in the class PAGA space, that tend to be higher, tend to be further booked into the future. So evaluate all of those things. Effectiveness and prior experiences, I think, are hand in hand, right? So you understand how effective a mediator can be by having either spoken with other members of your firm, spoken with the greater community, sending out an email to the listserv, hey, has anyone heard about this? Or your internal firm listserv. I know a lot of the large defense firms have that kind of banked information so that everyone can share in those resources. I think that's wonderful. And so there are additional things to consider with regard to these mediators. What is their follow-up like? Are they booked for the 8 hours of mediation and they charge for hours beyond 6 p.m.? Are they even willing to go beyond 6 p.m.? There are some mediators who have a hard cutoff and will not mediate into the evening. Do they bill for hours beyond the 8 or 10 hours of mediation itself? And if so, who's paying for that? Do you have an agreement with the other side to split those hours? Does it include phone calls or emails? And how are they billing that time? So that is something crucial for you to know before you book a mediator as well. Their approach to mediation. Again, some mediators have this mediator's proposed bracket that they like to do. Some mediators like to very, very heavily go through the facts and make sure that those are well developed and everybody is on the same page with regard to the facts before they get to numbers. Some mediators, if your briefing is robust, and if you've had particularly if you've had a pre-mediation call, they sometimes are willing to get to numbers a little bit more quickly because they've already vetted the factual information and the strengths and weaknesses of each of the claims. And lastly, do you trust that this mediator is going to effectively communicate your position? This is crucial. Some mediators make mistakes. We're all human. We all make mistakes, but sometimes they can convey something that they either weren't supposed to say or that is not truly what your position is. And so you need to make sure that you have this trust relationship with your mediator so that you understand, and developing those relationships with them, having these conversations outside of mediation, that helps you figure out what their language is and how they approach things generally. So I think that those are quite critical.
Absolutely.
Okay.
Next slide, please, Rin. Thank you. So one of the handouts that we provided today is kind of a scrubbed version of our mediation letter. It's a mediation letter that we send kind of as soon as we start talking about mediation, perhaps sometimes even before the mediation itself has been booked. Because these are the crucial pieces of information that we need to have a meaningful mediation. For both parties, a mediation letter is your opportunity, again, to explicitly state the scope of mediation as you understand it. It also is your opportunity to clearly state the relevant time period, which I think is crucial in PAGA actions in particular, because some people count back from the PAGA notice, whereas others count back from the filing of the PAGA complaint. So we want to make sure that there's a level and clear understanding of what we consider to be the relevant time period. It also can set expectations for timing. It's so important that we discuss as plaintiff's counsel when we need that data by, and for defense counsel, when you are able to provide that data. It is very rare to see a defendant who has the resources to be able to put, multiple staff members towards the production of time and pay data, that they would be able to, gather it together in a matter of months. Instead, they're probably going to need, half a year, or maybe later, maybe longer, depending on the size of the case. So being able to kind of really clearly set expectations for, that you're working on it, that this is when you think you'll have it prepared, this is when you'll have it ready to send over. It allows, it also establishes trust, because there's that open level of communication between opposing counsel. And we also use this as an opportunity to attach a draft MOU. It's one of our tips and tricks that makes mediations more effective. That way you don't have to waste time at the end of the day once you've already worked so hard to get a number that both sides have accepted. You don't have to argue over these tiny little things like what, percentage of attorney's fees, or if they're absolutely not okay with an escalator, or the allocation between W-2 and 1099, some of the smaller things that you could discuss prior to mediation, and at least get that kind of the dialogue about it going. In terms of party specific for the mediation letter, on the plaintiff side, this is your opportunity to have a data and document wish list. We're going to ask for everything. And that's your chance to initially make that ask. It's also your chance to kind of mitigate any risks about being shocked if defendant brings financial difficulty into play at the mediation. We would encourage you to have these kinds of discussions as soon and as kind of often as you can. But in the letter in particular, we use that as an opportunity to say, if defendant is going to bring up an ability to pay, these are the documents that we need to be able to assess that. Because, obviously we're not willing to just give a discount at mediation if that's the first time we've heard that there's an ability to pay issue. We need verification. We need to do our due diligence to make sure that we agree that there is going to be an ability to pay. And oftentimes that analysis needs to be backed up by documents. On the defense side, I think it gives you an opportunity to give data points that both sides can rely on, because it will derail your mediation, or you're at least going to spend a few hours up top. If plaintiff side thinks there's 10,000 work weeks and defense side thinks there's 20,000. And so if you're able to kind of come to the mediation at 9 o'clock, 10 o'clock with a set of data points that both sides can rely on, then you will have saved so much time that could have potentially been wasted. And I think also defense counsel can use this as an opportunity to explicitly state what was produced, what will be produced. That way there's no confusion. If your client only has one employee handbook, then you can say, we are producing our client's only employee handbook. That way there is no possibility that at mediation, plaintiff's counsel is going to say, we got a handbook from 2020, they didn't give me a new one. And there's no time wasted kind of trying to untangle the unknown, because we've been explicit with each other. We've had these conversations. And kind of as we've been saying throughout this entire presentation, we really stress this open communication and how important it is, and truly how the trust and communication can carry you through the mediation to a much better result and to a timely result. Barbara?
And as a tack on to that, with regard to the defense side, I encourage the defense to also send a mediation letter, because and it's actually pretty rare that we get in our practice a defendant who says, here's a list of all of the information that I need answers for. But I think that's great. I am more than happy to have these conversations with our clients, with our declarants, with other people, and find out this information and get that to them. And that sets up a more streamlined mediation. And it also sometimes raises things for the defense that they didn't know about. So for example, if an off the clock theory is that the employees need to show up at a workplace and they didn't know that they needed to clock in. There's only one time clock, and sometimes this time clock is broken, and they have to go to a different time clock at a different building, or whatever it is, or if they have to open up the workspace before they're even able to turn on the computer or the time clock. Sometimes the defendant doesn't know about that because they haven't been given that information. So absolutely ask those questions of your plaintiffs, hold them accountable, right? They need to know their case as well. And you need to have this information as a defense lawyer so that you can prepare for mediation and set up these calls. Which leads us to our next slide, which is, again, open and regular communication. I'm a mom of two, and I tell my kids that communication is the key to every successful relationship. And I believe that to be the case, not just in life kind of generally, but also in the practice of law. And what we do while we are adversarial in nature, it doesn't have to be antagonistic, and it doesn't have to be personal on any level. And so making sure that you have these open lines of communication are truly, truly the keys to making sure that there is a successful mediation before you ever get to the day. So setting up consistent reminders to follow up on the status of data and documents. Again, in the timeline that was provided, it talks about setting regular increments for having check-ins. So checking in at the 90-day mark. Hey, how's the status of that data and document production? Do you think that we're on track? Because again, since mediators are booking out so far into the future, it would be great to know, hey, listen, at 90 days, there is no possible way I'm going to have that data and document information to you in time for this mediation. You can look at rebooking, you can look at rescheduling, you can look at all of these things, but you can't do that if you're not having these conversations.
Right.
And I think that it is crucially important to have these conversations at regular intervals. So go ahead and, again, take a look at the timeline and make sure that you are scheduling these things. Just little tickler reminders. What we also encourage is having support staff or junior lawyers or law clerks. Involve them in these cases and rely on them. It gives them great experience. It also helps them being trained in the profession, right? We have a couple of great law clerks, some great juniors. It is wonderful to have them know that the best way to practice is to be organized and to focus on communication. So involve them in this process. Have them be the ones following up for data or sitting in on these conversations when you're discussing what the data means and what the documents are reflecting. With regard to your analyst, make sure that you are in communication about when you anticipate getting them all of the documents and data points. Also, if this is like an aggro case and you've got handwritten timesheets, give them as much notice as possible, right? That they are going to have a devil of a time trying to get all of this into a spreadsheet, and that they are going to need to take handwritten records and put them into a form that is going to be usable. So again, you won't know if you're going to be getting handwritten timesheets or handwritten changes to time punches or those kinds of things unless you're having these communications with the other side. So definitely make sure that you are scheduling communications and communicating with everyone that's part of this team.
So that brings us to the step of we have our data, we've gotten it, and we're going to get it to our data analysts or in-house, whoever is going to do it for you. On the defense side, we would strongly encourage that you examine your own records. If you have produced a sampling, we would strongly encourage you to do an analysis of that sampling so that you can see what the violation rate that plaintiff is going to come to the table with. And if you have all available data available for you to analyze, and that comes up with a different violation rate, we would really encourage you to consider whether or not you want to share that with the plaintiff. Because if you come to mediation and you say, I know that the sampling has a 18% violation rate, but I looked at all the data, it's actually only 6%. As plaintiff's counsel, we can't take you at your word on that. However, if you have communicated that to me ahead of time, if you have told me that that's what's going on, if you've offered to get me the rest of the data ahead of time, then I'm able to verify that. And then we can come to mediation again from a place of understanding and from a place of mutual understanding, which is going to save you so much time, especially with the mediator, because they won't be required to try to kind of communicate these different ideas to each other. So we would really encourage defendants to think of their information as a tool that could be used to kind of bring the parties together, as opposed to something that you can use, a weapon that you're using against them. That brings us to our next point, which is that attorneys who attend the mediation should personally examine the records. While we are not saying that you need to do the data analysis yourself, no need to look through thousands of lines of Excel pay codes. You should look at the records because there are some things that you might see that your data analyst does not see immediately. For instance, rounding. You might see just by a cursory glance, all of these time punches are at the quarter hour. Or you might look at a wage statement and think to yourself, is there a regular rate issue here that perhaps your data analyst wasn't aware of? And so it's so important that you take your own look at that so that you can understand what it looks like and so that you can see if there are any other issues that you want the data analyst to take a closer look at. Another thing that I would highly encourage for both plaintiffs and defendants is to ask your data analyst for exemplars. If they're saying there's a high violation rate on late lunches, have them give you a handful of examples so that you can come to the mediation and tell the mediator, here are 20 examples of late lunches. Here are 10 examples of regular rate issues. We really love to utilize a show as opposed to tell approach when it comes to mediations. Show the mediators the violations as opposed to just telling them. It'll have so much more impact and buy you so much more credibility to be able to do something like that. And a huge part of credibility is going to be looking at the data analysts findings yourself. And this should go without saying, but understanding them. You want to understand every single line on their finding sheet. You want to know what any of the underlying assumptions are going to be in that analysis. Did they assume that an alternative work week applies? Did they assume that what is the violation rate they assumed on the rest periods? Did they assume that meal period waivers were valid? These are all things that you want to really understand so that when you are at mediation and advocating for your client, you can say things with confidence towards the mediator, because particularly with class and PAGA, when we're looking at time records, we're relying so much on these violation rates and these numbers. And you truly need to understand what those numbers mean and how they were determined.
And I think that that's a great point. You have to obviously know what each of the analysts' lines mean, right? Yeah. And if you have questions, book some time with them, spend some time and invest in that. With regard to the first item that Danielle was talking about, with regard to a sampling, so oftentimes we are able to utilize on both sides a sampling of data and document production, and our mediation letter indicates that we are willing to oftentimes work with a sampling. If, however, from the defense perspective, you produce, let's say, a 33% sample, but you are also going to do an analysis of 100% of the data, I think that you're setting up a situation where you may have to turn over all of that information, because the entire point of mediation is exploring whether or not an appropriate and a resolution can be reached, right? And so if you are finding, in using Danielle's example, that the sampling indicates a 17% violation rate on meal periods, but if you are looking at 100% of the data, it's only a 6% sample. That indicates that there's a problem with the sampling. And all of class settlements need to be approved by the court. The PAGA is going to have a little bit more flexibility depending on what county you're in. Sometimes it can be done by stipulation, like in San Diego. But if you are finding that there's a problem with the data, you have to communicate that, and you have to be on the same page. If there's a 1% or 2% difference, that's likely not going to be statistically significant. But again, have that conversation with your data analyst as well, because if you are finding that there is a statistically significant, sorry, it's a tongue twister, difference in what 100% of the data reveals versus what the sampling is that you've exchanged with plaintiff's counsel, you're going to have to explain that. And you're going to have to account for that in order to make sure that the court is 100% informed as to why this is an appropriate settlement value for the case. Okay, next slide, please. Getting declarations. So I think that what I'm about to say may be a little bit controversial, but I would encourage both sides to either agree to getting declarations or not getting declarations. And regardless, you need to speak with people, right? You need to have this conversation. That is where, as a plaintiff's attorney, your best asset is your client. And especially if your client has a lot of phone numbers, a lot of colleagues that they used to work with, make those phone calls. Again, use those law clerks and junior lawyers to get experience. Have them talking to these people, have them doing interviews, sit in on a couple of them so that they can understand, one, that you are there supporting them, and that is certainly of utmost importance, but also that you can ask some follow-up questions and give them a little bit of encouragement to do that and to explore a little bit more, because certainly when a witness tells you something, there are follow-up questions that need to be asked. So the training on asking those follow-up questions is totally valuable and necessary for what it is that we do. So in that regard, I think that you should work on preparing a script and an outline for these kinds of calls. And again, if you have law clerks or junior lawyers, rely on them. Have them making these phone calls. Oftentimes, particularly in the class and PAGA sense, and especially in aggro cases, we're talking about people who are not necessarily English speakers. So make sure that you are engaging someone who does speak their language, literally, figuratively, all of the things, so that they can feel as comfortable speaking with you as possible. And with regard to the declarations, if you are obtaining declarations on either side of the V, I encourage you, again, maybe controversial, but to exchange those. I know that sometimes on the plaintiff side, we have declarants who don't want to have their names used at the time of mediation, and that's fine. You can scrub them. You can scrub them for identifying information. So job titles, names clearly, shifts sometimes is an identifier. So you can scrub those things. But what is important is that you communicate to the other side, yes, this is not just happening with my 1, 2, 3 plaintiffs that are named in this case. This is happening on a broader scale. And the implication of that goes to, if the case doesn't settle, it goes to class certification issues, right? Typicality, commonality, numerosity, all of those kinds of things. So just consider maybe exchanging some of those declarations. At minimum, share them with your mediator. On the defense side, if you are obtaining declarations, I think that what is important is sending them to the plaintiff side. And I certainly understand that you don't necessarily want their names disclosed, but what is important is how it is that they are experiencing or not experiencing these kinds of violations, so that we have that information and we can value our case appropriately as well.
Absolutely.
And the next slide, please. So this all leads again to this on the timeline. We're at roughly 2 weeks prior to mediation. So ideally, in an ideal situation, you will have already gotten all of your documents to your analyst. You will have gotten your data points to your analyst. You will have gotten your beautiful model. Sometimes they're color coded. I love that model back from your analyst. And when you do that, you have to have sufficient time to ask your analyst, hey, what about this? Or did you consider this? And what is it that you're finding? And as Danielle mentioned, you will have your examples. You will have your listed sections that you could screenshot and you could share with the other side. These are the violation rates. And if you're on the defense side, you will have all of your pieces where you say, penalties were paid. Sometimes there are more penalties paid than there were violations on the records. So if you have that, share that. So this, again, takes us to about 2 weeks before mediation. And when I'm encouraging you to have open and frank communication in a call, oftentimes I think the best thing to do that is face-to-face, right? Set a Zoom or a Teams where you are having this conversation across the table from the other side, and have this conversation about what the data is, what it reveals, and what it means. So this is laying the groundwork for these important relationships with the defense counsel, with the plaintiff's counsel. And we have had some mediations recently where both sides have gotten frustrated with the mediator, and the parties want to have conversations with each other, and it yields great results because we have invested this time and effort and open communication with the other side. And I think that there's something truly valuable for your clients, for the defendants, for the plaintiffs, for everyone in having these open and often conversations. So during this pre-mediation call, again, you're investing in the relationship. You are also giving information about your firm. You are talking about what your resources are, talking about what your strategies potentially might be if the case doesn't resolve, and letting them know that if you are, for example, a solo or a very small firm, that you handle a small amount of cases and you are prepared to take all of them through certification and continue this litigation process if the other side doesn't want to come to a resolution. And that's fine, right? Everyone should be approaching mediation with a plan B, a plan C, a plan D, and be willing to roll with the punches. That's certainly something as a litigator that we need to do very well. Also, during this call with defense counsel, plaintiff's counsel, make sure that you're asking questions and say things like, hey, I noticed that there's a 75% violation rate on these meal periods, or it looks like there's an auto deduct going on because I'm not seeing time entries for these meal periods that were backed out. Can you explain that to me? What does that actually mean? What are you seeing on your side? What do your declarants have to say about that? Ask these questions. Your mediator is going to ask them. So why not have this conversation with the other side in advance of mediation? Also, setting expectations about what the settlement value is. So if you have a case where there's a 2% meal period violation rate, or it's PAGA only and there are more premiums paid than there were violations on this sampling, you can talk about what an appropriate value might be. You can say, listen, I understand that there are mitigating factors here because the facts, your client's pretty clean. I get it. Like that's a thing. But here's my counter to that, right? And that goes back to the beginning of our presentation when Danielle was talking about making sure that you are the factual expert in every aspect of your case. You need to be prepared to say, but sure, you've paid these violations, but what about rest periods? There isn't a single rest period premium that was ever paid by anyone. You have all these shorts and there's a problem with your waiver or whatever it is. Make sure that you're prepared to have those factual conversations because that all goes to settlement value and what's appropriate value for these cases. And again, at this 2-week mark, it's a great time to raise again whether there is a financial wherewithal issue, because no one wants to book a mediation, go through this process, and spend all this time and money engaging an analyst and all of these kinds of things to only find out that the defendant is going bankrupt. You don't want to hear that as a defense lawyer because you're not going to get paid. We don't want to hear that because the aggrieved employees and putative class members are not going to get appropriate value for their claims. And it will potentially be a large waste of everyone's time and money and resources. And no one wants that. So again, from the defense perspective, if you have information about financial ability to pay, make sure that you're raising that early and often. And plaintiff side, don't be afraid to ask. You have to have these difficult conversations because if you won't, no one will. And I think with that, we can go to the next slide, please.
Okay, so we have all of our information. We've talked to defense counsel. We understand their point of view. And now we are preparing our mediation brief. The first thing that I would ask you to consider is, who is your mediator? Is it someone who does wage and hour class actions every day, 5 times a week? You probably don't need to put that much case law in. You could probably just rely on the facts of your case. Whereas if your mediator is a retired judge, maybe fresh off the bench, they probably want to see some case law. Maybe they want to see that you have an understanding of what the underlying case law is going to be before they get all of the facts thrown at them. So I think, it really harkens back to having relationships with these mediators and building upon how they operate. You want to write your brief for them. You want to write your brief for your audience. And some of the more practical tips that we would encourage you to consider is a highlights table. On our first page of our mediation brief, we put a highlights table. Our 3 or 4 best claims. We put our violation rates in there. It really gives the mediator that immediate understanding of how strong your case is and what you have to back it up. And, we truly do get complimented on this highlights table from various mediators. Really often they love to have this information right at their fingertips. And so we would really encourage in the preparation of your brief for you to think about what your strongest claims are, and then why not put them front and center for the mediator to see immediately. Another practical tip would be to utilize the SNP tool. It goes back to what, this concept of show the mediator what's going on, don't just tell them. So if we see that there is a problematic policy, if we have one of those exemplars for a late meal period with no corresponding premium, then we drop that directly into our brief. No need for the mediator to flip through and look at an exhibit, or in this day and age, they have to, click the arrow button to try to get to the exhibit on their PDF on their computer. No, it's right there in the brief for them so that it catches their attention more. It allows them to really understand and see, how strong that claim is because you're willing to show them the evidence of that claim upfront and immediately. And then I think I'm going to compete with Barbara for the least popular thing or controversial thing that anyone has saying. I would really strongly encourage in the preparation of your mediation brief not to over rely on templates. I know that we're attorneys, love a good template. However, a mediation brief is really your opportunity to tell a story of your case to the mediator. And every case is different. Although the underlying claims might be rooted in the same California Labor Code sections, the facts behind them are completely different. What makes one meal period violation in one case strong could be completely different from what made a meal period violation strong in a different case. So I would encourage you instead to really look at your mediation brief as different pieces that can be rearranged and stacked in a different way to present your case to be kind of the strongest that it possibly can be. And when you overly rely on templates, I think it also, it narrows your viewpoint. It narrows your focus into trying to get this case to squeeze into the template, as opposed to making the mediation brief work for your case. If we could have the next slide, please. And so finally, some tactics and tools that may not be appropriate in every case, but that you might want to consider in others. One is a site visit. I think it obviously really depends on who the defendant is, what kind of work sites we're talking about here. But for a plaintiff's attorney, it could be very much worth it. And for a defense attorney, so easy for you to arrange usually. But you are able to answer questions with such a level of confidence if you've done a site visit. If there is, for example, a donning and doffing issue, you can tell the mediator, I've seen the locker room. I know, how it works. I've seen that it does actually take a good 5 minutes to get from the locker room to where you have to clock in. If they're, and this might be a little, but perhaps not relevant anymore, but if they're still doing temperature checks due to COVID, try to get there in the morning, see how long it actually takes. Do people truly line up for temperature checks? If you've seen it with your own eyes, then you can explain to the mediator that this off the clock claim, it's not a throwaway claim. It's a real claim. I've seen it with my own eyes. I've seen the time spent. I've seen, the people, the workers, the uncompensated time. I kept my eye on the watch. When you're able to answer those questions with that level of confidence, it really gives you so much credibility with the mediator. And it really puts some real weight behind some claims that, generally are just purely based on testimony. Another tool that we would consider that you might want to consider is having a third-party financial analysis, either ordered or done. If you know that there is going to be some sort of financial difficulty issue, it is our obligation and our duty to take a closer look at that. And so we would, it is one of the things for you to consider whether or not you want to either order a financial analysis, or if you have someone in-house, CFO, an accountant, CPA, it's one of the additional tools that you could use to kind of get you to the mediation with all of the information that you need. Another thing to consider, historical settlements. Has this defendant settled a case like this before? And if so, what were the circumstances around it? What were the claims? What is the relevant time period? Have they changed their policies since then, or have they not changed their policies since then? You want to understand all of those things. Take a look at who opposing counsel was in that historical settlement. What do you know about that firm? Look at their docket. Was there any motion practice? It's so important for you to really understand what, especially from a plaintiff's perspective, what the defendant has gone through before they've gotten to this point with you, because obviously it'll inform the decisions that they're going to make at your mediation. If they were just at a mediation and they paid, $4 million 2 years ago, that is absolutely relevant to you, for you to consider. And then another thing, quite controversial, I know, Barbara has some opinion about pickup 6 agreements. So kind of briefly, I'll say that pickup 6 agreements, I think a lot of defendants might hear the siren call, think about it. But for most class actions, I think it's really quite difficult to get enough pickup sticks agreements to make a dent and to really affect the outcome of the case. Another thing would be that the way that pickup sticks agreements are rolled out, you should expect if you're a defense counsel and you're rolling those out, that plaintiff's counsel is going to see a copy of it. They're going to see a copy of any accompanying letter of the release agreement. And if they are able to invalidate it, you bet they're going to try. And so if you are going to, if you're considering doing something like that from a defense perspective, I think you really need to be careful and really consider what the risks are. The risk that your client is going to pay out some of these pickup sticks agreements and that perhaps the plaintiff could get them invalidated, or that, and making sure that people are making an informed decision. Did you have anything to add about the pickup sticks agreements?
I've had, again, a lot of conversations with defense counsel who seem to share that sentiment that it is oftentimes not worth, the juice isn't worth the squeeze with regard to pickup sticks agreements, because you might be able to save 10%, 20% of a potential class, but at what cost? Because you're still going to have the remaining claims and you're still going to have to litigate the case. And it just doesn't seem that it makes a lot of financial sense for defendants. And that is one thing additionally that I wanted to flag that we put into our mediation letter, is that we have, again, open communication with the other side. And we say, what we are going to want from you is an agreement that your client will not engage in a pickup sticks campaign until at least 30 or 60 days or whatever it is after mediation, because so many of these mediations are also going to proposals and they need time to be considered. Mm-hmm. So that's why we give ourselves a little bit of additional time, because oftentimes these cases get settled later. And the only other thing that I wanted to flag was with regard to the prior slide with preparing the mediation brief. I'm so encouraged and so uplifted to see so many mediators in attendance today. And so thank you so much for being here. And we want to give them the tools that they need in order to have both sides be successful. They are working very, very hard, and they need the ammunition, right? From both sides. So if you are a defense attorney, you absolutely need to have the information about violation rates and how many penalties were paid and things like that. And I do apologize that we are 2 minutes over, and I see that we have one question in the question and answer from Judge Khan. Thank you so much, Your Honor. The question is, are other PAGA class cases pending or may have been settled? Problem of reverse auctions when more than one case are pending. So talking about Turrieta. I think that is a little bit of a longer answer than potentially that we have time for. However, I think that reverse auctions are certainly a problem for the industry. And again, I think that the problem overall is solved with open and honest and frank communication with the other side. So thank you, Your Honor, for bringing that full circle back.
Exactly what I was going to say. I was going to say that while we don't have a magic solution to, top filing or reverse auctions, one of the strongest tools against that is truly just having open communication, not just with defense counsel, but once you've found out that there is another case, let's reach out. Let's talk to other people of our community to see what we know about this firm. Do we already have a relationship with them? And all of those things are going to inform, how you can meaningfully make a decision to move forward and to make sure that your case doesn't get derailed by someone else. And with that, I think that brings us to the end of our presentation.
Thank you so much for everyone in attendance.
There is a link. It's in the chat to the materials. Thank you. Thank you so much for attending. We truly appreciate your attention and your last hour.
Absolutely. Thank you so much.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.